live.
Hey everyone, good morning. Welcome to the Ass Cracking Dawn coverage of the rendition hearing of Julian Assange. My name is Steve Poikinen. I'm joined this morning by Andrew Smith. We also have our first guest of the day, returning guest. In fact, Nikki's here with us again this morning. And let's kind of catch everybody up from yesterday, because the anonymous witnesses were allowed after we had already wrapped. So if you want to jump in with that, I think you're a little bit more familiar with what's going on.
I'm not seeing Nikki's video, are you?
No.
I was not either.
Sorry?
No. But I can touch
Your
on
video's not working, Nikki.
Oh, my video's not working. Oh.
You might need to reconnect.
Okay. Sorry?
You might need to reconnect.
I might need to, yeah. Okay, I'll do that. Okay. All right. Give me a moment.
So with the witnesses yesterday, I'll read over the end of the thread here. This is from Defense Assange. Now dealing with the issues of the defense requesting the anonymity of two witnesses. The prosecution says they are neutral, but it's up to the judge. But the defense has to prove that harm would come to them if their names were released. The defense says both parties already know the names. It's just to keep it out of the public. The judge notes that these two witnesses have already been granted anonymity in a Spanish court, and we can deduce that they're two former UC Global employees that will testify about the surveillance company spying on Julian Assange in the Ecuadorian embassy. They're former employees of David Morales. Tells a judge in Spain that his company was making records of the cyber activist and his lawyers for the CIA. The defense explains that witnesses are taking measures to stay safe, fearing retaliation from military-trained David Morales.
Yeah, we can see you now.
Cool.
Okay.
Guns found at Morales' home with serial numbers missing. The judge suggests that employment details and testimony were already taken for Morales to know who they are. The defense lawyer, Mark Summers, is discussing Morales' reference to his American friends. Summers explains that the aim of the Spanish proceedings was to determine the chain of command who Morales was taking direction from and who the American friends are. Summers says the duty of this court is to reduce the risk of witnesses such as these, even if we can't remove it entirely. Morales may well know who they are, but the fact that he alone may know could be what is certainly protecting them. As it stands, it's working at this time, meaning that these witnesses haven't been killed in the Spanish proceedings. The judge says that there is no need to continue, and she says, I am with you in the need to anonymize them. Says the fact that the Spanish courts has already granted them anonymity means that the UK will respect their decision. The judge now grants anonymity, and the procedure is for the defense to pass the statements privately to the prosecution and the U.S. to confirm their identity so they can be read. Let's hope this takes less than 24 hours, or no more than 24 hours. And then this is a statement here about who the rest of the witnesses are. The defense and prosecution have agreed on several witness statements, including that of Noam Chomsky, Stefania Maruzzi, Cockburn, and several others. This leaves just Andy Worthington, Jamel Jeffer to potentially be called live, and then the two other witnesses who still need to be agreed on. The statements will be read into court tomorrow morning, and Andy Worthington will be called live tomorrow afternoon. Jaffer has been scheduled to testify Friday, but may be able to agree or may testify Thursday. And then this is the final statement here. The prosecution cannot receive instruction from the U.S. government on the two anonymous witnesses because they do not yet know who they are. The prosecution intends to argue that their evidence is irrelevant.
Which is kind of funny, seeing as how the Spanish courts just issued a subpoena for Sheldon Adelson's head of security.
We didn't get to that article last night because it was last night, but
right.
I would like to go over that just at some point today. Or
maybe we can do that when there's a recess or a lunch break.
Just as an update for everyone else that'll be joining us, we have Gordon, who will be coming in after lunch today, and then we have Ian Rose, who will be joining us at the top of the hour. So I actually have to get the link out to Ian. But yeah, so I'm looking forward to that.
I'm gonna go make coffee, y'all.
Okay, so going over to Mary Kostakidis's thread, and going back about an hour. Mary, well, first of all, I enjoy it thoroughly when she editorializes, and she says you have to wonder the extent to which we have forfeited our humanity and vigilance of our freedoms when there is so little media coverage of this historic trial. I agree, I do. Yeah, and we just kind of went over this rapid reading of witness statements today and tomorrow. So she's got a little bit on Patrick Coburn's statement, testifying on the importance of WikiLeaks releases and establishing the truth about the wars he has covered, including the fate of 2 Reuters newsmen in collateral murder, other incidents involving civilian deaths, including children. Brigadier Carr had to admit in Manning's trial that there had been no deaths due to a WikiLeaks disclosure. WikiLeaks is a news gathering organization doing exactly what journalists are intended to do. And then there was a statement from Ian Cobain of The Guardian, reported on the rendition program and treatment of individuals by the US and the UK, and UK complicity in US activities. The impossibility of uncovering state crimes and difficult to obtain evidence. Mary editorializes, says that the judge appears to be listening intently. We can come back to that. And also included in Cobain's statement, the importance of reliable documentary evidence, citing examples of individuals who have been tortured. He gives examples of attempts to deceive journalists and threats to journalists. UK tried to cover up collusion, but ultimately had to investigate and conduct an inquiry. All of this can't be comfortable to the judge, Mary says. Concludes whistleblowers and journalists are vital to expose this. Now on to Stefania Maruzzi's statement. And I think I want to go over to Mo for this. He says Stefania Maruzzi's statement is now being dealt with by Mark Summers, who is summarizing key aspects of it. Collateral Murder and other publications dramatically showed criminal acts. The publication was of immense importance and public concern. Stefania's statement has more to do with like the public's right to know. And she's basically laying out the case that because this was in the public interest, it needs to be recognized as such. And this is the only court that she's going to have the opportunity to do that in, because if Julian ends up in a U.S. court, as we know, there is no public interest defense in an Espionage Act case. Ms. Maruzzi sought out Mr. Assange and WikiLeaks after Collateral Murder to work with them for the opportunity to expose manifest lies upon which wars had been waged and to change the course of history. She says the cables I was handling were primarily of Italian or Vatican interest, but had broader interests such as the Guantanamo-related files. One such revelation was Seymour Hersh's expose of Abu Ghraib. Though their impact was reduced in 2004 by U.S. government position that these were a few bad apples. And the point there, really, at least to me, is that had there been Had Seymour Hersh been able to disclose more about, U.S. military prisons other than just what happened at Abu Ghraib, there was a ton of, let's say, diplomatic cables or other documentary evidence that Abu Ghraib wasn't a bug, but rather a feature of U.S. occupation, might have had a little movement on it sooner. Revelations from WikiLeaks could change policy and change the state of the war. Says Moruzzi, Italy is the only country in the world which has convicted U.S. citizens, almost all of them CIA officers, in relation to extraordinary rendition. See the case of Abu Omar, was kidnapped in Milan in 2003 and was later tortured. Italy commenced an investigation on 26 U.S. citizens. Extradition procedure was thwarted. They were nonetheless convicted in 2012-2013. None served a day. The U.S. refused to assist, and the CIA officers and others received a presidential pardon, an act later condemned by the European Court. WikiLeaks provided indisputable evidence of U.S. pressure on Italian authorities to thwart the investigation and prosecution of CIA officers responsible, as well as the complicity of then Prime Minister Berlusconi. Without the WikiLeaks release of diplomatic cables, it would have been impossible to be fully aware of the facts of the situation. Moruzzi confirms the seriousness with which Mr. Assange and WikiLeaks took in respect of security and redaction of potentially sensitive information, which could unduly lead to harm of innocence. Ms. Moruzzi's work started in January 2011. 9 months later, in October, she was still analyzing the cables. She worked with WikiLeaks on appropriate redactions. She was given an encrypted USB stick, a password given after arriving in Italy. She was aware of the password David Lee was given by Assange. Her password wasn't the same one. This is the first time Ms. Moruzzi had worked with an organization that had such strict security guidelines. This was considerably beyond anything she had experienced. Even work done by close colleagues of Ms. Moruzzi covering the Italian mafia, which required serious security measures, never reached these levels. When she learned that David Lee and Luke Harding had published the password in their book, even the part Mr. Assange hadn't written down, she wondered if they understood the procedure at all. Keeping passwords private is a very basic security measure, she said. She was with Assange on 26th of August, the day after Der Freitag article revealing that a password of the unredacted cables was available. She encountered enormous concern on the part of Mr. Assange and every widening awareness that the files, until then secret, would nonetheless become public. WikiLeaks could not have remedied the situation. Julian was clearly acutely troubled by it. After Cryptome had published the cables, every possible step had been taken. Assange was himself making urgent texts to inform the State Department the information was out of WikiLeaks' control. And then we've got Guy Goodwin and Robert Boyle's statements. Somebody wants to pick up on those?
Yeah, I can pick up on Goodwin's. Guy S. Goodwin Gill's statement briefly address. He was the UN High Commissioner for Refugees. He visited the Ecuadorian embassy where Mr. Assange was with asylum, later discovered that he thought there was a private conversation, that their private conversations were spied on by UC Global, who acted for the CIA. Robert Boyle's statement is being summarized. The U.S., he says U.S. lawyers had written down on misuse of federal grand juries. That includes the details on Chelsea Manning, including her statement to the court-martial court from February 2013, and why she disclosed information to WikiLeaks. Grand juries have been misused to collect information or to collect evidence despite historic prohibitions on that use, to compel people to give testimony against their will despite the right against self-incrimination. GJ, grand jury secrecy. Neither the court nor public can engage how they will use and abuse, including to disrupt political activities, criminalize political movements, especially those on the left. A witness held in civil contempt for failing to cooperate with a grand jury can be jailed for the length of the grand jury and can be brought back and asked the same questions and jailed again. There is no upper limit on criminal contempt. Manning, through counsel, filed a motion to quash the subpoena for her to testify before a grand jury targeting Mr. Assange. She argued that it was further punishment for leaking to WikiLeaks and gave a full statement on her court-martial. She arrested the U.S. government, or asserted the U.S. government, sought to set a perjury trap. Following this, she was detained at the ADC, which is the Alexandria Detention Center in Virginia. Once there, she was placed in solitary confinement, despite the statements concerning the effects of prolonged isolation resulting from the trauma of previous confinements. Initially, after arriving at ADC, the jail placed Manning in administrative segregation, despite concerns from her lawyer. She stayed there for 28 days without any misbehavior, experienced difficulty having attention on anything, anxiety, and was with a spiraling inability to handle the symptoms, vomited on the floor after succumbing to vertigo. Manning was again dragged back into the prison after yet another grand jury proceedings were initiated, after she was ultimately released on the basis that no amount of incarceration would compel her to speak to a grand jury. The court denied the motion to quash and found her in contempt and ordered her to jail for the life of the grand jury. She was fined $500 a day and eventually $1,000 per day. It was clear the sole and dominating purpose of the grand jury subpoena was to gather evidence against Mr. Assange, not a lawful use of grand juries. Manning said in a statement to the U.S. courts, which imprisoned her, the motion was denied. She remained incarcerated. A second statement is being read by Robert Boyle. The statement notes how Manning continued to be incarcerated and was kept in deplorable conditions. The statement from Niels Melzer's the UN torture expert, in terms of treatment of Manning, is quoted in the Boyle report, being summarized by a member of the defense. The further application noted that after nearly 1 year in prison, Manning attempted to take her life. The U.S. court immediately dismissed the grand jury on the basis that it was no longer needed, and Manning was released. She nonetheless faced $256,000 in fines. And to add my own little editorializing, we know that her wonderful friend at Anarch Kelly was able to help her raise that money in 48 hours to pay it off.
We also know that it's codified into U.S. law that as long as the judge believes that giving someone more time and more fines will break them, it's legal for them to keep that person incarcerated. As soon as the judge makes a determination that, punitive financial measures and more incarceration aren't going to get the judge or the grand jury what they want, he has to release them. Chelsea Manning made it perfectly clear from day one that she wasn't going to participate in the grand jury process. So they tortured Chelsea Manning for well over a year, because even though they knew ahead of time that they weren't going to break, the state had to flex muscle and show power over, anyone connected to this grand jury, and use Chelsea Manning as an example of what happens when you refuse to play ball with the empire. In this situation, Chelsea Manning hands down won, and she beat them.
Yep.
And now she streams on Twitch 4 days a week.
Yep. And please follow her, XY Chelsea 87, I believe it is.
86, I think. I think.
Oh, one of those. If you look up Chelsea Manning Twitch, it'll come up. I apologize. We usually have the link up. I just don't have it on hand. So Mo continues, a statement from a jury consultant and experts is now explaining the jury pool that would fill the jury in the trial against Mr. Assange if he is tried in the U.S. The indictments against him are filed in Alexandria, Virginia, which we know is the Eastern District of Virginia. which is literally national security court. The only people that live there are spooks and the family members of spooks, or people that they're not going to call onto the jury panel. John Kiriakou actually went through this with the person that was doing his jury selection, who was the same as O.J. Simpson's lawyer that was doing jury selection, and literally told him, like,
yeah, he got OJ's jury consultant.
It's
Yeah,
87. It's 87.
87.
So
XY
you're
Chelsea 87 on Twitch. But literally, John Kiriakou was told basically, like, you're fucked, bro. Like there's no way to get this jury any less stacked.
No, they're not calling fucking Dave the landscaper for this.
No. But that is where Mo's thread ends. Unless we got some. Yep. So we are all caught up with Mo.
Assange Defense has the entire statement from Bridget Prince, the executive director of One World Research, and that is all. That's strictly jury pool.
Okay.
Which is nice because they're real. I mean, like, you know, John talks about it whenever he's interviewed, but rather than hearing it fairly frequently on consortium news, I don't hear much of a discussion about what a U.S. jury would look like in the Eastern District. So I guess credit to Joe and Liz Voss for remembering to mention that frequently.
Mm-hmm. So how are you today, Nikki? I don't think we've had a chance to really chit-chat yet.
I'm fine. I'm listening to everything you're saying and having some ideas, a few comments or questions. Well, first of all, it's interesting how through this trial, this sham trial, the world is learning about the US legal system. Grand juries and prison conditions and torture. And, you know, it's quite obvious that the grand jury judge, I think it's the same one, I forget her name, another woman, interestingly enough, of the fairer sex, lots of women from the fairer sex, Gina Haspel, and others. Anyway, so this grand jury judge is guilty of torture as far as I'm concerned, in terms of what she's done, at least to Chelsea Manning. And I don't know what the US law, the domestic law is on torture, but somebody should think about going after that judge for torture.
Well, we have two different sets of constitutional protections against torture, but just like the constitutional protections of free speech, they're just irrelevant to the people in power. That they just change words and write laws to be able to get around it.
Mm-hmm.
Which
but,
the biggest thing. Oh no, go ahead.
Laws that are unconstitutional. I mean, they can write laws around the Constitution, but laws that are unconstitutional are invalid.
Mm-hmm.
And so they should be challenged every time there's an opportunity. But the other thing I wanted to say is that, again, I think I mentioned this the other time, these special courts are very similar to the special courts that Hitler set up. So it's a fairly good analogy. You know, I mean, it's as if this special court in Virginia is even higher than the Supreme Court of the US. It seems to have even greater powers. And I'm surprised that nobody has challenged any decision in a higher court, any decision that comes out of that court or even the grand jury. I don't know how the grand jury works, but it's amazing. It's an amazing system for people who look at it from the outside.
It's quite incredible looking at it from the inside, like being a part of the United States, being a U.S. citizen, being like, holy shit, like my government has this much power that they can wield over me for literally just talking about information.
They're just so fucking corrupt, man. Like,
Mm-hmm.
it's gross. I feel sorry
Have
for
they
any
been
whistleblower.
Have they been around forever? I mean, when was the system of grand juries set up? Was it?
Well, in Chelsea's statement, and I'm sure we'll go back to it at some point and read it, But she actually gives a long history of grand juries and how they were
Okay.
once used. And I hope I remember all this right because I hope I can do it some justice. But grand juries were historically used to be like a civilian investigation around a court. So there generally wasn't prosecutors or attorneys. It was just one person against another person with an arbitrator and a jury pool, like just people from the city essentially, making decisions on the case. And then over time, it's been increasingly corrupted, where it used to be if there was a prosecutor involved in the grand jury case, that was like blasphemy. But it's gotten to the point that now that's all it is literally just another prosecutorial system outside of the general judicial discretion. And it becomes a lot harder to challenge it because it moves differently through the court system to where you don't get a chance to just appeal a ruling or a decision like that. There's time delays. There's literally getting locked into these
That stuff's
cases.
not even in the public record, is it? I mean, a lot of
I
that
don't. I
shit's
don't believe
secret.
so.
Yeah, so we can't even as like citizens, know what the hell's happening in these things. It's they shouldn't exist at this point.
Yeah. Yeah, no, they shouldn't. It's an aberration of the worst kind. I'm amazed that the civil liberties groups in the States haven't made a lot of noise about this and tried to get rid of this thing. It's a monster.
A lot of our civil liberties groups, they're more than happy to lick some boots. It's weird.
Oh, yeah. Okay. Yeah. Yeah. That's a problem.
Like
Mm,
if you're not on their team, they'll certainly
yeah.
Yeah,
Okay.
it's a really weird dynamic.
Mm. Well, I mean, it's time for the US people to make some radical changes. They're going to have to clean up this horrible mess in terms of the institutions, these medieval type institutions even existing. So
I mean, just
something's.
the FISA court alone existing is just ridiculous. It's what
Mm,
98% or something like conviction, rate, and it's just like
Oh, in the Eastern District?
yeah, those FISA courts, isn't it like hasn't there been
It's
like 3 cases they've denied or something for those
yeah, and that's
warrants?
over its entire history and none in the last like several decades.
Yeah, it's just it's crazy to me how much shit like that we have in our justice system here. It's really weird.
yeah. Well, I don't know. Mm, The land of the free needs different institutions. You
Absolutely.
know, there's no point in pointing the finger at China and putting and whatever for their human rights.
I mean,
It's
the only thing
record.
we're not doing is shooting journalists. I mean, we're no better
Oh
than
no,
any of
that's
these
happening
places.
also. That's also happening with the
No,
Black
true,
Lives Matter. No,
true.
they are shooting. They
Yeah,
are
there
actually
there have
shooting
now been
journalists.
since Julian was illegally removed from the embassy, there have now been over 1,000 journalists in the US that have been
Holy shit.
shot at, maced, tear gassed, detained, beaten, otherwise intimidated, threatened, and harassed by the police.
Mm,
And that's not a coincidence.
I didn't realize
no,
that number was that high
and
now. Wasn't
It
it
was
all?
700 from Memorial Day of this year to like
Jesus.
we left for DC.
That's insanity.
mm, and it's not just in the US. I mean, this thing, in France as well with the Yellow Vest movement. There've been lots of journalists injured, arbitrarily detained. Um, so yeah, and this started to happen in a big way after Julian was shut down, even before he was arrested.
Yeah, the hashtag I use is the Assange effect because
Yeah,
it's
yeah.
just they feel like emboldened now or something, so they're just like, ah, fuck
Yeah.
it, we don't need no veneer on anything. We're just gonna do what we
Uh,
Mm.
want.
According to Assange's defense, the defense now moves from Bridget Prince's testimony to the anonymous UC Global employees or anonymous witnesses from the embassy spying case. I'm assuming they're UC Global employees, but so the next several moments are going to be brought to you by the CIA and Sheldon Adelson.
Yay!
Can't wait.
Now, are they just reading statements from them, or are they actually? Okay, that's what I thought.
In fact, I'm not 100% on this, but it sounds like today might be all witness statements.
And no cross-examinations?
Yeah, Kevin said in his wrap up yesterday that they might even be done by like Thursday. So tomorrow.
They just said that they've got somebody testifying in person or in person on video on Friday.
Okay. But he said, yeah, they're running out of witnesses.
UC Global witnesses.
I suspect they're not going to be in the court because they're like they had to agree to anonymity to even have their stuff put in because they fear for their lives and junk from UC Global or whatever. So I'd be surprised if they actually testified in person. Defeat the purpose.
If I was the witness that was the top security guy for Adelson, I'd be terrified.
Right.
Definitely he's identifiable. So he's either got I'd be shaking my boots if I was him or her. I suppose I assume it's a him. Interesting how they didn't subpoena Adelson to come and give a statement.
I am shocked.
What's he gonna say though? I'm only responsible for my head of security's activities while he's working. I don't know who he moonlighted with. I didn't know anything about them. Sands just hosted the conference. I don't know anything about what happened there.
That's why he needs to be cross-examined. It's on cross-examination that you catch people who say, I know nothing, I remember nothing. What's my name? Where am I?
I see nothing, I hear nothing. What is that old show? Hogan's Heroes?
Yeah.
That's what it reminds me of.
Some Sergeant Schultz shit.
Now, the only thing he might say to get out of it is that he's got the right not to incriminate himself. He might say, I refuse to answer that question on the grounds that it may incriminate me.
So we have, as of 2 seconds ago, Defense Assange putting out the first tweet about UC Global.
Okay.
They say, Witness 1 explained what UC Global does, how it obtained a flashy contract with Las Vegas Sands, owned by Sheldon Adelson, whose financial ties to Trump are well known. So that was and then 13 seconds ago, UC Global Director David Morales, after securing the contract, said the spying company would now be playing in the big leagues. I think the exact words were first division, making a soccer reference, and had moved over to the dark side.
According to Mary, the first witness, it says, was a 50% co-owner of UC Global with Morales.
Wow.
Oh.
So this isn't just, low-level goon.
No, partner in crime.
This is going to be fun to go back through and source all these tweets once these statements come out. Do we know if there's anywhere that they've released these statements by the anonymous members of UC Global?
I don't know.
And
Tarek should be able to. He got the rest of the witness statements.
Okay.
And you have an odd notion of fun, Andrew.
Oh, I know. I mean, when it's 6 o'clock in the morning and you're reading over shit like this is about as good as it gets.
Well, I imagine that as long as their identity is covered up, that there's no problem in releasing their statements. Because in any case, those statements are read in court fully. So, as it's still an open public hearing, as long as the anonymity is maintained, it should be okay to publish the statement.
And then Mo has here, this is as of 3 minutes ago, catching up, there's only 3 tweets. A statement by one of the anonymized members of the security firm UC Global, translated from Spanish, is being read out by Mark Summers QC. UC Global was hired for security for the Ecuadorian embassy and the president's daughter in London. Employees with Spanish nationality able to move freely and reside in the UK by virtue of the EU citizenship to work unimpeded. After CEO David Morales traveled to the US, UC Global obtained a flashy contract. Las Vegas Sands, whose proximity to Donald Trump is well known. The contract did not make sense because the purpose was to provide security to a boat belonging to Mr. Adelson, but it already had security. So the contract with UC Global wasn't written up for back channels into the Ecuadorian embassy or anything like that. It was just, hey, can you watch my boat for me? And then turned into spying on the Ecuadorian embassy and apparently, potentially, the Ecuadorian president's daughters in London, which I think is which is like as much as a disturbing thing as spying on Julian. The fact that these same people were tasked with watching the president's daughters.
Right.
Apparently,
we gotta teach
Morales.
Kathy how to live tweet.
Yeah,
Apparently, Morales is not in prison, on remand in prison. He's walking around freely whilst his case is being heard. Interestingly enough, there you go. The Spaniards are much more civilized.
Well, if you had a multi-million-dollar multinational mercenary army, I think there would be a little hesitation about keeping you in jail too.
I mean, you don't even have to have a mercenary army in the U.S. You just have to have money. They'll put you in
That's
there.
true.
Although something tells me that Morales has lost any kind of protection that the CIA would have been able to provide him this late into the situation he got himself into.
Well, they don't have loyalty. They don't have loyalty.
Epstein. He might be Epstein outside.
If we see memes going around with David Morales didn't kill himself, we know that there's a problem. But one of the things to point out here is something we went over on the Vigil maybe last week. The Spanish court has requested information about the servers and people involved in this case to the U.S. government, and the U.S. government says, give us their names, or we're not giving you anything. You have until the end of October to respond, or we'll think that you're not interested. So even as justice is sought in this case, the U.S. government's saying, no, we're going to kill those people. Tell us who they are so we can do it, and then you can move forward with your case.
Yeah, they don't even try to hide it anymore.
No. Oh dear.
For real though, how fucking weird.
They can subpoena. Sorry.
Go ahead.
Well, it's not the same system. Under the common law, you can subpoena the documents without saying anything about the names because it's easy. It's easy for them to find out what documentary evidence, even if it's on video, it's still documentary evidence. They know which documentary evidence we're talking about. The stuff that went from the Ecuadorian embassy about Julian to the CIA. We don't need to know we don't need to know the names of the people working for the UC Global who fed that or were involved in feeding that information to the CIA. So under the common law, they would have been able to subpoena the actual documentary evidence. Yeah, something to think about.
So, like 30 seconds ago, Kevin Gostola tweeted out, Witness 1 says Morales had a real obsession in recording lawyers' meetings with Assange because, quote, our American friends were requesting it. This is going to be some damning fucking testimony right here, boy.
So on top of everything else, right, on top of the politicalization, on top of the mental health issues, on top of the detention conditions, this right here is akin to how the Pentagon Papers got thrown out. Nixon had plumbers go in, wiretap Ellsberg.
That's okay. Let's be very clear about this. Nixon had spooks go in.
Dressed as
They
plumbers.
were called the White House plumbers because they were supposed to be stopping the leaks.
Mm-hmm.
I mean,
because, you know, clever.
Correct me if I'm wrong, but when they read out the witness statements, doesn't that mean that both sides are agreeing on that testimony?
Yes.
So they're just straight up admitting that, oh yeah, we spied on him. Like, even the prosecution, like that. Why is this case going?
This is the big curveball here. The tweet at the end of the day yesterday, let me find this real quick, kind of gives light to what is happening right now. We have the prosecution, and this is, I'll drop this link into chat for everybody. The prosecution cannot receive instruction from the U.S. government on the two witnesses because they do not yet know who they are. The prosecution evidence is so not that they wouldn't be able to just hand this information over as the good little prosecutors that Dobbins and Lewis are, but the fact that this is something that they a pre-prepared statement made, that this is already admissible through a whole nother court, and that they're essentially at this point trying to do damage control about this whole situation. Because these couple tweets here in and of itself are the reason that this whole case should be thrown out, among all of the other reasons the whole case should be thrown out, because of the breach of client-lawyer confidentiality. Because that's ultimately how Daniel Ellsberg won his case, and it got thrown out, was because of the intelligence community's infiltration illegally of his place. And while it is legal...
It was a psychiatrist's office.
And while at the time it was legal in Julian's situation for like mass wiretappings, reading everybody's email, it's not legal to go and put microphones in the women's bathroom. It's just not. And I don't think that that's something that...
It's not legal to, first of all, the UC Global went in there and tapped the whole place under false pretenses, saying that they were there to protect Julian. So he never consented to being spied on, and neither did the Ecuadorian embassy consent to being spied on.
Hello? All right, hold on, y'all. I'm checking out what's going on here.